Hi friends, this is Krish, the Urban Naxal. I have a bad throat, please excuse me for that. But I'm otherwise fine. Got some throat congestion, cough and all that. Anyway, so there was an important development yesterday, that is 9th January. We had been called to Kurla Court for receiving a copy of the charge sheet that was made against us and kind of formally handing us over or presenting us before the magistrate at Kurla Court. So Sion Police Station had called us, and it was just one long procedural day, very tiring, the whole day, lot of time waste, all that. However, the main point of the matter is that a charge sheet about this thick was presented before the magistrate, and we were given copies of this charge sheet. Now, what is a charge sheet? Just so that you guys are clear. When an FIR is filed, the police has to the police basically registers an FIR and then formally commences the investigation into the offense. Afterwards, they come to the conclusion that this offense has indeed been committed. And so, now it has to be, the accused have to be prosecuted before the courts, that is, before the magistrate. And so then, they file what is called a charge sheet. Now, a charge sheet is a document which connects the evidence that is there before the police, the evidence or the facts that were presented before the police, to the charges under various IPC section, Indian Penal Code section. So 420, that is cheating, and then there are sections for conspiracy, and there are sections for many people acting together with common intent, and so on and so forth, and of course other things like defamation and all those things are also there within the same FIR. So for the FIR, from the FIR to the charge sheet, it is the stage of police investigation. Charge sheet shows that police has finished investigation and now hands over the case to the magistrate, and then further prosecution will be done by the magistrate, or rather under the magistrate, by the public prosecutor. The public prosecutor is a lawyer who is hired by the state. It is possible that Runwal's lawyer will also appear, but it is usually not necessary for the opposition lawyer to appear. The complainant's lawyer does not have to appear. It is another story that they will probably send a lawyer, because the public prosecutor may not argue strongly enough, and we will argue. Of course, we are going to argue. So they are going to try to maybe send a lawyer from their side. He'll probably be a senior counsel from their side, and they are going to make arguments. I'll be appearing in person as far as possible, party in person. I started that yesterday. Of course, I was assisted in this by my very good friend Sushant Walimbe, who had sent his junior, Vedant Kulkarni. Vedant Kulkarni sort of walked us through the procedural parts, what is going to happen, how you have to do it. You need some amount of guidance from someone who's been there and done that. So Vedant Kulkarni was there to assist us and made our life considerably easy, sort of mediated between us and the cops to a very fair extent. And Sushant had given me an amazing judgment. I want to share something about that also. So this charge sheet, it's about this thick. Basically the charge sheet says that this is how the police concludes that we have cheated Runwal. And that is the substance, sum and substance of the charge sheet. the way they string the evidence together in order to reach the conclusion that we have committed the offenses of which we are accused. Now, we will be, of course, knocking down the charge sheet. There's a process called filing a discharge application, where we take that charge sheet and we dissect it, we analyze it, and we show that the so-called evidence does not stand up to scrutiny and does not add up to the offenses that are committed or allegedly committed, such as Section 420. How they come to the conclusion of Section 420 from this evidence is going to be questioned in court by us. And that is the process called discharge application, which we will commence soon. In the meantime, I'm also going to share the contents of the charge sheet. I'm going to have it scanned. Feel free to ask for a copy from me. Guys, I'm an open book. If there's an accusation against us, I am not going to be shy about it. I'm going to discuss it threadbare, and I'm going to analyze each and every part of that charge sheet and let you guys analyze it. It's part of a learning process. I don't mind being part of this experiment. I enjoy being part of this experiment. It's a huge social experiment, and quite honestly, I feel that people should do more of this. Get into trouble a little more. We should get into trouble a little more. Knowing that the system can be used against us, we should still do some of this, because that's how we learn, and that's how we need to learn, and that's how we need to fight against these guys. So that's what I'll be doing going forward in this month or two. We have a date. The next date is 28th April. 28th April. Okay. So we are going to be presented before, or we will have to present ourselves before the magistrate's court on 28th April. But I want to share something else about yesterday's proceedings. So my friend Advocate Sushant had sent me a very interesting judgment of the Supreme Court in SLP, it's a special leave petition filed before Supreme Court in 2017. It is called Sushila Agarwal versus State. I'm going to share that also with you guys. Sushila Agarwal versus State is a very interesting special leave petition which concerns the life and liberty of people like myself who are accused and who are going to be tried. And what is the procedure for giving bail or for arrest or for, the whole thing. Anticipatory bail, arrest, and so on and so forth. What are the powers? It kind of defines, or it kind of limits the powers of lower courts. Not limits in the sense of, or let us say it moderates the powers of the lower courts to prevent harassment of people who are accused. So, very interesting judgment. I quoted this, I gave a copy of this judgment to the magistrate, and the order that came out in terms of our need to furnish a bail bond was moderated by this judgment. I am not saying it was 100% success, but there was some measure of success that we achieved by just handing over that judgment, marked copy, and also explaining the contents of that judgment and saying, please pass the order in terms of this SLP judgment by Supreme Court. So the magistrate did pass an order. He didn't mention the Supreme Court judgment. I said, please mention it. He said, no, it is taken on record and I have passed an order in accordance with that. I'm going to take a look at the order after it is uploaded. I'm going to dissect it. We will take a look at the order. I'm going to share it with you guys after it is uploaded, and we'll discuss the aspects of it. And if there is a fight, now this is a kind of a side road. Okay, our main fight is against Runwal. Actually, our main fight is by social media. Our method of fighting is not the courts. Their method is the courts. We are forced to fight through the courts because they have chosen the court. They have chosen the criminal system and the civil legal system. So we are fighting. Going and fighting about have the necessity or the lack of necessity to furnish bail bonds, etc., is a bit of a side road. It is not the main road. However, sometimes these side roads are also important because they can help a lot of people, and they can overall enhance the dignity of the Indian citizen in the grand scheme of things. So I am going to read in any case this judgment to you, Sushila Agarwal versus State. I am also going to possibly take it up as a fight, although as I said it is a side road, but sometimes it's important. So just contemplating it may not do anything, may do something. In any case, feel free to reach out to me. In case you are an accused, Sushila Agarwal is a case that helps you. I am Krish the Urban Naxal. Jai Maharashtra, Jai Hind, Jai Jawan, Jai Kisan.